Bismillahirrahmanirrahim. Distinguished guests, ladies and gentlemen, thank you for joining us today for this webinar on how ADR can achieve SDG 16, Peace, Justice, and Strong Institutions, hosted jointly by Bangladesh International Arbitration Center and Accord Chambers. I am Rubaya Ehsan, counsel at BIAC. Today, we are joined by expert panelists who will deliberate on the topic, and we will begin with welcoming remarks from the Chief Executive of BIAC and Senior Partner of Accord Chambers. I would first like to invite Mr. Rumee, who is the Chief Executive Officer of Bangladesh International Arbitration Center since October 2015. He started his career with ANZ Grinleys Bank in Bangladesh in 1975 after completing Masters in Economics from the University of Dhaka. During his career with ANZ Grinleys Bank, Mr. Ali worked in India, UK, and Australia. In 1997, he was appointed as the CEO of the bank's operation in Bangladesh. A former deputy governor of Bangladesh Bank, Mr. Ali was chairman of BRAC Bank and CEO of Standard Chartered Bank Bangladesh. He also served as the managing director, enterprises and investments of bank, BRAC. Currently, Mr. Ali is the chairman of AB Bank Limited. Sir, over to you.
Thank you, Rubaya. Mr. Mahbubur Rahman, chairman of BIAC, Mr. Mamun Chowdhury, senior partner at Accord Chambers, learned panel of speakers, Mr. Akmall Azad, moderator of the session, and our distinguished audience, good morning and Assalamu alaikum. I remember many years back, I was invited to speak on small and medium enterprises and access to finance. What I realized when preparing the paper is that the phrase access to finance actually hides the real issue by not phrasing it as it should be, denial of finance. One can only create access after we accept that we have in fact denied access. In the SME issue, the financial institutions put in place some requirements that effectively denied access. For example, they wanted security, collateral, formal accounts from small businesses to extend financing, which by definition they didn't have. This I considered denial of access. The central bank then ensured access to an extent by making it mandatory for banks to lend a certain percentage of their loans to small and medium enterprises, thereby forcing banks to give access. What do we have in the case of access to justice, which countries, including Bangladesh, have undertaken to provide under their constitution or under the SDGs? Let us see what we have agreed to. SDG 16 calls for government to promote peaceful and inclusive societies for sustainable development and provide access to justice for all. What is meant by justice here? Does giving access to file a complaint to an aggrieved person mean giving access to justice? On the basis of these two questions, let us examine, is access denied? If not, is justice accessible? Let me answer these questions. First, under SDGs and our constitution, we have committed access to justice for all. Justice does not mean filing a case, but actually getting an effective and enforceable verdict for a complaint filed by an aggrieved person. So we can define justice as the execution of the verdict that delivers a remedy contained in the verdict to the aggrieved. Therefore, access to justice means reaching this objective. Nothing less can constitute delivery of justice. If now I ask the question, is access denied? I would say yes, it is, on the basis of the financial cost of litigation and taking on to its finality, which can be months to years, it is denied. Sections of society who cannot afford the cost are denied access. Even if we make initial access easy, the fact it takes years and huge financial commitment, contacts, and influence to an extent I would say justice is not acceptable. Here I'd like to quote an article which appeared on Daily Star on 19th March 2019 to support my contention. In this article, written by Mr. Sikandar Zulkarnain, the then Joint District Judge of Tangail Judge Court, titled Three Dimensions of Access to Justice for Achieving SDGs, he says, and I quote, "As a judge, I have personal experience of disposing some civil suits after 30 to 40 years of their institution. The parties who had access to justice mechanisms through instituting these suits died long ago without getting their desired justice. They got access to justice system, but not justice in true sense because of delayed disposal of their cases. Having established, I believe, that we do have twin issues of denial of access and effective access to delivery of real justice, we come to the moot question of this webinar, and that is how ADR can achieve SDG 16, peace, justice, and strong institutions. Can ADR be a regulatory parallel to what Bangladesh Bank did in the case of access for small and medium enterprises? This distinguished audience is a discussion I will leave for a very learned panel of speakers to address. Under the very skillful moderator, our director, BIAC, Mr. Akmall Azad. We will also have the important task of introducing our distinguished members of the panel. With that, and not trying your patience any further, I hand you over to Mr. Azad. Thank you all.
Thank you so much, sir. Before we proceed, I would like to invite Mr. Mamun Chowdhury, who is an advocate of the Supreme Court of Bangladesh and senior partner of Accord Chambers, a Dhaka-based corporate law firm. He successfully represented major conglomerates in numerous international commercial arbitrations and in several high-stake arbitrations and litigations in the telecom, construction, and energy sector. He represented a wide range of banks and financial institutions in numerous litigations to facilitate recovery of multi-million-dollar loans. He obtained Bachelor and Master of Laws from the University of Dhaka. Mamun sir, over to you.
Thank you. Mr. Mahbubur Rahman, Chairman BIAC, and Mr. Muhammad Rumee Ali, Honorable CEO, Mr. Director of BIAC and other distinguished panelists, Assalamu alaikum and good morning. I would like to bring my thanking BIAC for its commitment and hard works to establish institutional arbitration process in Bangladesh. ADR can play an important role in access to justice and ensure rule of law. BIAC has been playing an important role to create awareness, trust, confidence in ADR in our legal system. We all know that we have very time-consuming, complicated, and expensive litigation process in our country. The government has been trying sincerely to ensure justice, to access to justice for all people without much complication and delay, and therefore government have enacted some laws keeping in mind ADR, but our litigant has not getting any benefit out of them. However, most of the litigant and people connected with legal profession are not aware of ADR so far, I think, and they are not aware the benefit and effectiveness of ADR. ADR can play a vital role in our judicial system, and it can reduce the time and expense for litigation. However, for a long time, we have been trying to establish ADR or alternative dispute resolution arbitration in our country, but due to lack of institutional arbitration, we have been failed for a long time. However, BIAC has been trying to establish an institutional arbitration process here, and we hope their journey will be successful and we will achieve our goal shortly. And we, Accord Chamber, we would like to thank BIAC to give us an opportunity to participate this event. And I hope the distinguished panelists will discuss many things from where we can learn many things about ADR and its benefit. And we all will be benefited by the discussion. Thank you all for joining.
Thank you so much, sir. Now it gives me great pleasure to hand over the session to our moderator for the day. Before we proceed, I would like to introduce him briefly. Mr. M.A. Akmall Hussain Azad. He is director of BIAC. He has been with us for the last 4 years. As director, he is a former career bureaucrat. Among his many assignments, he served as additional secretary, Ministry of Agriculture of the Government of Bangladesh. He also worked for the civil judiciary for a while before joining administration. Mr. Azad had his honors and masters in law from the University of Dhaka, and he studied public administration in the University of Manchester, UK. Mr. Azad was trained on local level governance in India and on legislative drafting in Canada. Azad, sir, over to you.
Thank you. Respected Chairman of BIAC, Mr. Mahbubur Rahman sir, learned panelist discussions. Good morning. This is the 14th webinar of BIAC during this hard time of COVID-19. We're just trying to let audience and our competitors understand that we still exist during the pandemic. We are fighting out relentlessly. We have the privilege to co-sponsor this event today with our partner organization, Accord Chambers, which is one of the leading law chambers of the country. Today's subject is how ADR can achieve SDG 16, peace, justice, and strong institutions. While there is no single definition of access to justice, it is broadly concerned with the ability of people to defend and enforce their rights and obtain just resolution of justiciable problems in compliance with human rights standards, if necessary, through impartial, informal, or formal institutions of justice and with appropriate legal support. Access to justice is necessary for people to redress their grievances, access their rights and entitlements, and for the realization of the broader sustainable development agenda. Without the inclusion of a measurement on access to civil justice, there remains an important gap in the global monitoring framework for the implementation of the SDGs. Today, we have an eminent panel of speakers. I wish they will speak from their individual perspectives and enlighten us on the subject. Of the panelists, I have the privilege to introduce first Dr. Mahfuzul Haque, who is an adjunct faculty in South Asian Institute of Policy and Governance at North-South University, Dhaka, and teaches public administration and political science. A former career bureaucrat, Dr. Haque retired as Additional Secretary to the Government of Bangladesh, who is a PhD in public administration from the University of Dhaka. He did MPhil from the University of Bergen, Norway, a postgraduate diploma in rural policy and project planning from the Institute of Social Studies at The Hague under the Erasmus University of Rotterdam, the Netherlands. Dr. Haque. Please unmute your speaker. Over to Dr. Haque.
Good morning. Am I audible?
Yeah. Thank you.
Okay. Good morning, distinguished Chair of BIAC, Mahbubur Rahman, distinguished Chief Executive Officer, Mr. Rumee Ali, Advocate Mamun Chowdhury, distinguished advocate of Bangladesh Supreme Court, distinguished moderator, my colleague Akmall Hussain Azad, distinguished panelist, and distinguished audience. At the outset, let me thank the organizers for inviting me and to speak and share my insight on this subject, though I'm not a legal expert, but since I was a practitioner in the field of public administration from my long service. Whatever insight I have, I would like to share. I have prepared a slide. Let me move to the slide. Okay. Now the topic is peace and justice, strong institutions, SDG 16. How can ADR achieve SDG 16, peace, justice, and strong institutions? I begin my talk with few questions. Can we achieve lasting peace in a society unless we have strong institutions? Can we also achieve peace and strong institutions unless we have governmental effectiveness, sound regulatory regime, rule of law, and other conditions necessary to establish good governance in the country? So those are the starting point. Citizens of a society can hardly expect and enjoy peace and justice if there are deficits in rule of law, good governance, and low trust in public institutions. Institutions include regulative, normative, and cultural cognitive elements. Therefore, good governance, rule of law, absence of violence, strong institutions are priority conditions for sustainable development. In absence of it, no matter how robust we have a regulatory regime, peace and justice will be a remote possibility. So the purpose of my talk is threefold. First, to assess the ADR practices in light of the regulatory regimes in Bangladesh. Second, to assess people's propensity to seek legal and resort to ADR for redressal of their grievances. And third, identify some challenges for further improvement. As it goes, basically, it aims to promote peaceful and inclusive society for sustainable development. The CEO has aptly pointed out the denial of justice and access to justice. So these are broad questions, and how ADR can really solve these two problems. Now, out of 165 countries, Bangladesh ranked 109 with a score of 6.3.5 in SDG score. So Bangladesh is lying somewhere in the middle. And according to the SDG index score, Bangladesh is one of the 3 countries that have progressed mostly on SDG index score compared to other countries. So that's the good news. Now, ADR refers to a set of practices and techniques aimed to reach an agreement between competing parties, facilitated by a neutral agent. Now, advocates of ADR argue and that ADR reduces transaction cost and the outcomes are mutually beneficial to both the parties compared to any other conventional litigation. Now we have a fairly robust regulatory regime. Now, to what extent these regulatory regimes are being actively enforced, that's a big question. Now, according to our statistics, where does we stand as a country in terms of ADR? Now, from 2009 to 2020, according to the NLSO, National Legal Aid Services Organization, 64 districts, the data that they have produced, that disposal of ADR has been 41,714, and that led to the recovery of a huge sum of money. And there are other legal aid provisions, legal aid services in the Supreme Court. And we also have a helpline call center that delivers access to legal aid and services. Now, the legal aid services so far, they have rendered these services quite commendable, but there are more challenges and we need more access and more in terms of awareness building so that more people are aware of it. The services recipients of legal aid services, according to NLSO, is on the rise. So this is the good news that more people are now getting access to these legal aid services. And of course, that will also lead to a more resolving of conflict through alternative dispute resolution. Now, out of 12 targets of SDGs, target 16.3 entails promotion of rule of law. And this rule of law is a huge concept. If we have a law and if it cannot be enforced, and if the enforcement is not being meaningful and acceptable to the parties, or if the verdict or decree gives rise to further dispute, then there's no rule of law. So what we are aiming at, basically, we want to establish some rule of law which is sustainable, which is lasting, and that outcome is acceptable to both the parties. Now, simultaneously, I would also like to bring your notice to the worldwide governance indicator. That gives you a broad picture where we are standing in terms of rule of law. Bangladesh, according to the 2017 ranking, Bangladesh scores 28.37. In 2019, the rule of law index score rank is 27.88, compared is much lower compared to other South Asian counterparts. So we need to do more on this rule of law. Regulatory quality is also, compared to other countries, I have missed the score here in my slide, but given the figures, it also looks that we also have a good regulatory quality compared to other countries. Political stability and absence of violence, we also score very low in this segment. Now, according to the SDG dashboard, that gives you a broad picture across the countries where we are standing in terms of achieving SDG 16. According to this dashboard, it says that with regard to SDG 16, major challenges lie ahead, and the successes, whatever we claim, is stagnating. So we need to actually make progress, and we have a huge pile of backlogs of court cases, and there are various arenas for SDG where we can apply this. Section 30 of Public-Private Partnership Act, Section 36 of Real Estate Act, International Center for Settlement and Investment is exceed. That gives you a broad spectrum of avenues where we can apply ADR. And in South Asia, we have a good score to 2.25 compared to other regions of the world, and some pending cases in exceed. NICO Exploration, NICO Resources Limited versus Bangladesh Gas, NICO Resources Limited, Bangladesh Oil and Gas Mineral Corporation. These cases require active attention and proper attention of the authorities if you want to make good progress. How economies in South Asia resolve commercial disputes. Bangladesh ranks 189 and score is 22. So we also have a low score compared to other countries. Enforcement of contracts, it takes long days, 1442 days to get a settlement through courts in commercial or enforcement of contracts. Is very long. Now, to conclude my topic, I would say that ADR mechanisms need to be accessible and comprehensively regulated. The contents of the governing instruments are very important. Whatever inside the contents. So if you can develop some template that would guarantee the interests of both the parties, that would be excellent. So the contents of the ADR instrument, that gives the, that should be actually looked into. Now, most of the people are not familiar with the term ADR, so it has to be broadly, discussed, popularized, and also the success has to be showcased. Now, technology, manpower is an issue, but then again, how we can incentivize the actors to play out more on ADR. Now, the 85-year plan of Bangladesh, it has succinctly captured the challenges and way forward to make progress in this segment. Lastly, I would like to conclude that we must realize that SDG 16 is a contingent upon a priority situation, which must not be neglected, a peaceful and a just society. And if that is our goal, we must try to make our governmental system effective, establish rule of law, and we try to, make a peaceful Bangladesh. That's all from my side. Thank you for your attention. Thank you so much.
Thank you, Dr. Haque, for your beautiful presentation well within time. You have rightly said that we have to create more awareness building among citizens and streamlining the governing instruments for arbitration, which may well advance progress on SDG 16. Thank you so much. I'm also grateful to our CEO, Mr. Rumee Ali, who has rightly pointed out two important issues: is access denied and is justice accessible? And he has discussed the issue very effectively, and we have learned from him enormously. Now we move on to the next speaker, Mr. Tariq Rafi Bhuiyan Zoon, who is the Secretary General, Japan Bangladesh Chamber of Commerce and Industry, and the Managing Director, New Vision Solutions Limited, Dhaka. He is an entrepreneur, management consultant, foreign direct investment policy expert, and technology enthusiast. He co-founded a software development company in 2002 in the USA that has implemented more than 250 projects. He has also co-founded a profitable management consultancy company in international corporations such as Nestle, Yamaha, Toyota, Oxfam, JICA, Jetro, Ajinomoto, PwC, etc. Mr. June.
Thank you so much, Mr. Azad. BIAC Chairman, Mr. Mahbubur Rahman, BIAC CEO, Mr. Rumee Ali, Mamun Chowdhury, and Mr. Suhan Khan from Accord Chambers, all the other distinguished panelists and audience. Assalamu alaikum and very good morning to you all. My name is Tariq Rafi Bhuiyan. Thank you so much for giving me this opportunity to have this talk in this distinguished among the distinguished panelists. So I will be talking mostly about the ADR and the SDG 16 in terms of foreign direct investment. Because my background, I am the General Secretary of Japan Bangladesh Chamber of Commerce and Industry, where we have about 240 member companies. They are mostly either Japanese companies or Bangladeshi company doing business with Japan. Also, through my company, New Vision Solutions Limited, which we formed back in 2008, we had the opportunity to work with more than 100 different foreign companies, predominantly Japanese companies. Mostly, more than 90 companies have been Japanese companies. So we have seen a lot of issues about, the dispute resolution. Also, when the new companies are coming, what they are thinking and all those. So I would like to talk a little bit about that. I'm also the advisor, infrastructure advisor to the Embassy of Japan at present. So if we look at the World Bank Ease of Doing Business Index, right now we are faring at 168 position, which we cannot be proud of. Though we are, coming up through a lot of different efforts of the government. However, we are still, there is a long way to go. And my previous panelists have spoken very specifically about, the rule of law and the other index, how we are faring and all those. When we, when the new investors are thinking about investing in Bangladesh, they definitely compare with some of the other countries. So they definitely look at this index, as well as they, in this index also there is, very important indicator like the inefficiency of the judicial system in resolving the business disputes. So enforcement of the contracts. So as a consultant, when I talk to the investors, when they ask me that how is the judicial system, I have to tell them, that it will be taking, if you get into the court system, it will take you months, sometimes years, sometimes it can be 10 years. So one of the previous, speaker has told that sometimes, it is taking so long that the person who wanted justice is actually no longer alive. So, this is really alarming to any of the foreign investors who are thinking about coming to Bangladesh. So right now, because we are talking about ADR, we are extremely excited that, BIAC is in place, and it is actually doing quite a lot of, resolving a lot of cases right now. So a lot of times when I see the companies who come to me after getting into trouble, when we look at their contracts, a lot of times we see that there is no mention of arbitration. So this is another issue. If it is not mentioned, then they definitely will have to go to the judicial system, court system. So that also makes them go into a very long and excruciating process through which the justice is is very delayed. It is also extremely expensive. Then they will go for appeal. So it's just a never-ending process. And for any business institution or business companies, time is of essence. So if it is taking too long, then it's of no use to them. So we believe that BIAC, we should be making it more aware. So there should be an awareness program in places like BIDA, BEZA, BEBZA, and other foreign joint chambers, and then FICI. Why? Because a lot of these foreign investors, when they come, they first come to these organizations, and then they talk to the people for different advices. So if BIAC's pamphlet and some of those things are there and it is distributed to them, at least they can have this in their mind. And companies or consultants like us, we are also trying to talk about these to the companies who are planning to come to Bangladesh. And definitely we tell them that when you're doing any kind of contracts, you have to make sure that this clause is included. In the arbitration clause, it should be mentioned. So I think if we can do these things in a good way, it will really help the investment to come and flow more into Bangladesh. Right now, if we talk briefly about the Japanese investment, more than 320 companies are there, and a lot of other companies are coming because of the Arai Hazar economic zone, which is coming up, which is actually going to be managed by Sumitomo Corporation, which is a Japanese conglomerate who had done these in few other countries. So we are hoping that a lot of these companies will be coming very soon to Bangladesh once it is in operation in 2022, 2023. So we are hopeful that we will be, whenever we get a chance to talk to them, we will talk about BIAC. And just like I've mentioned, I think if the awareness program is more, we can talk about it in more platforms. It will be beneficial for the future investors. And if through the ADR process, definitely we are talking about SDG 16, then access to justice for all will be, I think, can be implemented, and it will, because of the court system, no matter how many more branches you create and other things, it will still have issues. So I really believe that ADR is the way to go, and I again congratulate BIAC for making these kind of webinars and having more enforcement of ADR through your system. Thank you very much for all of your patient hearing. Thank you.
Thank you, Mr. Tariq Rafi Bhuiyan. Thank you very much for you have rightly stressed on the importance of good governance and ensuring access to justice to attract foreign investors, and you have also favored strong ADR infrastructure, which will give comfort to investors worldwide and create a business-friendly environment so that foreign investors feel confident about entering the Bangladesh market. Thanks again. Now we move on to the next speaker. I would now invite Sheikh Jenefa Jabbar, who is the Director, Human Rights and Legal Aid Services, Social Compliance and Safeguarding, Bangladesh Rural Advancement Committee, BRAC, since January 2019. Earlier, she worked as the Regional Responsible Sourcing Director for JC Pini Purchasing Corporation overseeing South Asia, Middle East, and Africa. She has a decorated experience of working with renowned organizations including BRAC University, UNDP, ILO, and Bangladesh Garment Manufacturers and Exporters Association, BGMEA. Ms. Jabbar is a barrister at law from the Lincoln's Inn, UK, and she practiced law as an advocate in the Khanam Jabbar.
Thank you, everyone. I'd like to thank you for inviting me here today, and thank you to the Honorable Chair, Mahbubur Rahman, and the Head of Accord Chambers, Mr. Mamun Chowdhury, distinguished panelists, and the audience. My name's Jenefa Jabbar, and as mentioned, that I'm a barrister from Lincoln's Inn, UK, and I have been a practicing lawyer. I'm now the director of BRAC, and from that lens, I would actually like to say that we work with the marginalized women in the rural community and semi-rural area in 61 districts and 410 upazilas throughout the country. And I would like to, I have a presentation on how we actually provide access to justice and how we actually work on the SDG 16 pillars where access to justice is brought to the marginalized in the rural and semi-rural areas. If I start is that the Human Rights Legal Aid Program in BRAC is supporting the marginalized poor women and children through where there are family disputes on maintenance and dower, and also on inheritance rights. Under the Human Rights and Legal Aid Services Program, we also, one of the core elements of our program is ADR. And ADR, as you all know, is where it can be through negotiation, mediation, conciliation, or arbitration. We follow the fundamental principles of natural justice, where ADR, which allows third parties intervention into civil disputes, because compoundable offenses can be done through ADR, but the non-compoundable serious violence that happens, say, in the community, we have case support, which cannot be redressed through ADR. So if I were to show the categories of ADRs in the legal framework to bring some context, we have the formal judicial ADR, where the Code of Civil Procedure and the Orthorin Adalat and the Family Court's ordinance is there. But we have the quasi-formal situation, where the Muslim Family Law Ordinance, the Arbitration Act, the Labor Code, the Village Court Act, the Code of Criminal Procedure is there. But we also have the informal and non-formal ADR, where disputes are resolved through alternate methods at the community level in both civil and criminal matters by non-judicial body, which may be described as informal. Different NGOs in the country are working, where BRAC is the largest human rights legal aid organization right now, involved in dispute resolution at the community level. Why ADR? As you all mentioned, it's cheaper than litigation. It takes less time than court. It's confidential, unlike a court which is open to the public. It enhances access to justice to resolve disputes expeditiously, retains party relationships, and maintaining party autonomy by involving the third party. What type of ADR does the Human Rights Program at BRAC do? We do ADR in an informal and non-formal setting, and it's similar to other non-governmental organizations who provide legal assistance to people from marginalized conditions. BRAC provides the legal assistance through ADR and following a mediation process. We also have collaboration with DLAC in doing our work. What we do as a mediator, we guide on the law only. We maintain rules, so there are issues of fact and there are issues of law. We guide on the law, we maintain the rules, we are neutral. They are the people who are facilitating the ADR process, maintain neutrality. We are a facilitator, we maintain confidentiality, there is no discrimination, and we help to come to a solution. The human rights program, the issues that are capable of being mediated, we accept those complaints on issues of law, send invitation letters to the other party, attendance of both parties is ensured, and decide on the day, the date and time of conducting the ADR. We sit with them, we welcome statements and seek cooperation, we file up consent forms, and we set the ground rules, listening to both parties, and then we start with the first party and then with the second party. We present reasonable solutions and encourage the parties to adopt the best alternate approach and reaching on agreements and finalizing the decision. We prepared an MOU and necessary follow-up. So what we actually do, say if a woman is facing family disputes, we realize maintenance and dower money, we work towards resolving the disputes, and immediately on the day or the following day, we ensure that maintenance and dower money is realized. We maintain confidentiality. Lawful settlements of disputes take place through participation of the parties. The trust is in us, there is rationality, and it signifies respect and empathy, especially at the rural level. There are risks associated because we don't have, say, protection measures in the community. So we have a mechanism where the HRLS officers, the human rights officers, can reach out to the district managers, the zonal managers, should the other party propose any threat. We also have district managers speaking with the field operations team and the security management of BRAC. So we advise on filing general diary if we see that the issues are of a much more threatening nature. So we have a mechanism in place to also risk assess the situation. As per SDG 16, how do we contribute to SDG 16? We are working under 4 areas of SDG 16, so reducing all forms of violence and death, ending abuse, exploitation, trafficking at all forms of violence against torture and children, and promoting the rule of law. We have cross-cutting contribution as we receive maintenance and dower, then the woman is also being empowered. And as she gets empowered, we also link her up if she wants to get alternate skills employment, or she wants to set something up with the maintenance money she has received. That economic empowerment we also work on, as we have a skills development program in BRAC. So we hit on goal 1, we hit on goal 5 of gender equality, and goal 8 of productive employment and decent work, and goal 10 of reducing inequalities. To date, till December 2020, we started the legal aid program in 1998. We have received over 226,722 complaints, which have been resolved through ADR. During the pandemic, we had to immediately go onto online dispute resolution, where through conferencing mechanisms, we have continued the work of family resolution of disputes. And this is directly contributing to SDG 1613. We have realized till date over 353 crore BDT, and this has been realized as dower and maintenance. It has, like we said, it has an indirect contribution to SDG goal 1 and goal 5. What we provide is solution at the doorstep, and which is much needed for the marginalized people who are having family disputes in the rural and semi-rural areas. People get accessibility to the informal justice system to resolve the disputes at an initial stage at community level. We reduce the burden of court. We already have over 3.3 million backlog. So we reduce that pressure through this system as we have 37 million backlog cases. Women's empowerment, the money realized through ADR is used for economic empowerment through skilling and development training. So the overarching aim of SDG 16, we actually work on SDG 16.1 in significantly reducing all forms of violence and related deaths. SDG 16.2, ending abuse, exploitation, trafficking of all forms. SDG 16.3 on promoting the rule of law at national and international, ensuring equal access of justice to all. And SDG 16.9 by 2030 to provide legal identity for all, including pre-birth registration. We have many activities within the Human Rights Legal Aid Program for non-compoundable violence, etc. We provide case support, but I highlighted on the main ADR process, which is very important and without which many thousands of cases in the rural community could not have been resolved so quickly and ensured them their maintenance, dower, inheritance, addressing issues of inheritance law without these ADR facilities. Thank you, and I'm open to receive any questions.
Thank you, Barrister Jenefa, for sharing with us an account of BRAC's programs of providing free ADR support to people coming from marginalized and vulnerable conditions through its legal aid clinics across the country. We're happy to know that about 2/3 of the complaints received at BRAC HRLS program were resolved through ADR, including online dispute resolution methods. Now we move on to the next speaker. It's my privilege to invite Ms. Gauri Gokhale, who is a practicing lawyer and senior partner of International. She spearheaded several policy initiatives for the technology, media and telecom, pharmaceutical and information technology industries. She has been named in several legal directories, including the Hall of Fame in Legal 500, one of the foremost authorities on intellectual property management and protection strategy. Ms. Gokhale has been instrumental in devising IP litigation strategies of clients before several prestigious forums in India. It's your turn, Ms. Gauri Gokhale.
Thank you. Good morning to all of you. Chairman, thank you, Advocate Mamun Chowdhury, Suhan, and Mr. Azad. It is really a privilege to be here and sharing our thoughts with the neighboring country. We have had the privilege of working with the Accord Chamber extensively on several matters and have got the flavor of the litigation in Bangladesh as well. On this particular topic, which is really close to my heart, which is the rule of law and access to justice, a couple of thoughts I wanted to share coming from a neighboring country, and maybe a similar situation may be prevailing. So I'm just, explaining certain ideas that I have. So first of all, what we realize that most of the litigation starts or, is arising out of the laws which are uncertain or unclear, right? So I think that is the first step in my mind when we talk about access to justice, is certainty of the legal framework overall. The second aspect I want to bring to the table, and I briefly spoke with Suhan about it, what we have noticed in India, and I understand that is the case even in Bangladesh, is that government is the biggest litigator, right? And there are several litigations, whether it is arising out of writ petitions, which are government actions, or maybe even litigation with respect to, say, a PPP project and the like, right? Which is more in the nature of non-sovereign functions. So what one aspect I want to bring to the table is, are there any solutions available where regulatory litigation can be minimized by some ADR process? Because what we have realized is that when even the prior speaker spoke about the foreign direct investment, when any investor is looking at any country and they realize that there is a regulatory uncertainty and litigation arising out of regulatory action itself, will sort of come in the way of my business in India or in Bangladesh, right? That is one of the key issues. And if at all, ADR mechanism can also be made available for, disputes or government actions, that will be probably reduce a lot of burden on the court. The third aspect, when we talk about ADR, there are certain disputes that are arbitrable, certain that are not. So those which are arbitrable, I think, should reduce the burden of the court by moving their framework to the under the arbitration framework, and reduce the burden of the court to manage or deal with non-arbitrable disputes. So can we arrive at a solution? And the prior speaker gave excellent example that technically one can argue that family disputes are not arbitrable in that context, but you have provided an excellent alternate solution, and therefore we need to look at systematically ADR. In my mind, after examining what we have seen in India, ADR mechanism can only function extremely well if ADR is looked at each level of the dispute and each type of a dispute. And the example that you gave was excellent when it comes to family dispute. Your team has, the prior speaker, you really appreciate how, and in India also we see that how those are resolved at the doorstep level and reducing the burden of the court to that extent. Coming to the next point, I think what you've realized over a period of time, especially in the pandemic, the cost of litigation, the more and more companies, whether it is at the corporate level or even at the individual level, will want to avoid any kind of adversarial proceeding, because arbitration also is ultimately an adversarial proceeding, right? So mediation, can we have more people trained in mediation, and use that as a first step? Like in India we have now the Commercial Courts Act. Just to give an illustration, we have a Commercial Courts Act recently introduced to deal with commercial disputes between the parties, and they have articulated what those commercial disputes are. But interestingly, what they have done is that if you don't need any interim injunction in that dispute, there is a mandatory process of going for mediation before the matter is taken up as a suit in the court, right? So can we have a mechanism where we are able to resolve multiple things by mediation? And what I understand, and we had a very good presentation, one of the leading mediators who explained that it is to be done at a very emotional level, right? So it is not as if anybody can come and do mediation. So extensive training can be given for mediating these disputes. The next point is, I believe we of course spoke about arbitration, and our experience suggests that when you talk about arbitration, it definitely is costlier than the court dispute resolution. And the only reason that parties will go for arbitration is maybe for confidentiality and for the speed of the dispute resolution, right? So therefore, typically you will have commercial matters which are, where the corporations are involved. Those will be taken to arbitration, of course, and not the individual level matters. Very rarely you will see that. So when you have those type of matters, what our experience suggests, that ad hoc arbitration and versus institutionalized arbitration is definitely faring better in all counts, whether it is certainty of the cost. I'm not saying they may not maybe necessarily cost effective than the ad hoc, but at least the certainty of the timelines, certainty of the process is something we have definitely examined. In some cases in India, the institution also examined the award, whether procedurally that award is sound. So some amount of oversight over even the award process, right? So these benefits, we definitely believe that institutional arbitration is the way to go forward, because you do have a certain structured approach for the arbitration as an ADR mechanism. The next overall point I want to leave with all of you is that in terms of dispute, right? And we spoke about various various mechanism insofar as a peaceful society is concerned, right? So in that context, I believe that overall, when we look at dispute as a community or as a country, we should definitely look at in terms of minimization, even as a thought process or an idea. that how can we minimize even the trigger of that particular dispute. And as I said, that has to be done at different types of disputes that we have to examine. And sort of some of them can be reduced, for example, at the enactment level itself, right? At the drafting level. Some can be reduced as the procedural level. For example, in case of a government dispute, at the procedural level, can you reduce that? So at every level, first reduce the disputes, because if you are able to reduce the disputes, the balance that remain, the management can be much better. And I completely agree with Mr. Ali that he mentioned about access to justice. It's not only simply that I'm able to file something, but the feel that whatever has been done has been rightly done. The natural justice principles have been followed. Because if the process doesn't give me that confidence, I may not be happy with the verdict. But if I'm not even happy with the process, or the process that is followed to come to that verdict, then that itself gives me a kind of unhappiness and the lack of faith in the entire system. So I think that is the other piece I want to leave with the audience, that how do we ensure that even the each and every litigant, even if that person has lost, feels that justice has been done. I think I'll leave with that, and happy to take questions when we get into the question answer. With the permission of the chair, I may have to log out for some time because I have a court hearing, but I'll definitely come back after that court hearing is over. It's a short hearing. Thank you for inviting me once again, and really enjoying the discussion that we are having here.
Thank you, Ms. Gauri Gokhale, for sharing your insights about how India is promoting ADR as part of its drive to secure rule of law at the national and international levels and ensure equal access to justice. We're also privileged to be apprised of some of the notable progress India has made in strengthening its arbitration institutions. Thank you. Now we have the last speaker. I would now invite Mr. Suhan Khan, who is a fellow of the Chartered Institute of Arbitrators and Advocate, Supreme Court of Bangladesh, and managing partner of Accord Chambers, Dhaka. He represented as the lead counsel in a number of international arbitrations seated in Singapore and London. He worked as an international consultant and researcher for the University of California, Berkeley, War Crime Studies Center, and the East-West Center, USA. Mr. Suhan Khan, please.
Thank you very much, Mr. Akmall Azad, for giving me the chance. And thank you very much for having me in today's session. It is indeed a great pleasure and privilege to be in the company of such distinguished panel of discussants today. And I also thank BIAC for organizing this event in collaboration with Accord Chambers. And I also am grateful and thankful for all the participants who have joined us today here. So today's topic is basically goes into the very heart of access to justice. The very text of SDG 16 of the United Nations is quite broad. It requires us to promote peaceful and inclusive societies for sustainable development, provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels. So this surely must also include commercial dispute resolution, consumer dispute resolution, and all other kind of dispute resolutions, including disputes with the regulators, with the governments, family disputes, and wide range of disputes. All of these taken together, if we can address efficiently, we will be then able to say that we have promoted the rule of law at the national level as well as at the international levels and ensure equal access to justice for all. Now, the very fact that SDG 16 requires us to ensure access to justice is a reiteration of a very constitutional right, because access to justice is a fundamental right that is guaranteed by the Constitution of Bangladesh and goes into the very core of the broader field of justice and human rights. Securing rule of law, fundamental human rights and freedom equality, and justice for all citizens is thus enshrined in the very preamble, at the very beginning of our Constitution. Thus, access to justice has always been a commitment of the state towards all the citizens of Bangladesh from the very beginning of the founding fathers of our Constitution in the year 1971. Now, because of the SDG 16 and because of the fact that Bangladesh is a signatory and Bangladesh subscribes to the Sustainable Development Goals, it is no longer confined as a commitment between the state and its citizens. It is now also a commitment of Bangladesh as a state to the international community. And as our previous panelist, Mr. Tarek Bhuiyan has already mentioned, it is also a commitment to the various investors and stakeholders who intend to come to the into the jurisdiction of Bangladesh. Now, the very first place I would like to kind of stress on the fact what BIAC CEO Rumee sir has mentioned. Sometimes it takes 30 to 40 years. There are ample examples of this to get a verdict that is final or that has reached its finality. If that is the case, then the original litigant who is no longer there, although he got the access to file a suit, he has been very much denied the access to justice because he never got the justice during his lifetime. As Dr. Mahfuz has already said, that Bangladesh lies in the middle in terms of SDG scores. So that is actually quite a positive thing. But I think that keeping in mind to the ease of doing business, in which Bangladesh is not in a very encouraging position, I think we should ensure that people get access to justice, not only at a time that is required to be shorter, but also more readily available and accessible. Now, in order to ensure that, what can we all do? Well, that is a $1 million question, which everybody has been trying to acknowledge and address over the past years. The United Kingdom, in the year 1998, wanted to kind of reform their own civil procedural systems. And therefore, they kind of enacted their own civil procedural rule, or the CPR, in 1998, in order to reduce the cost, delays, and complexities involved in the litigation system. So the fact that there is delay, cost, and complexity in the litigation system is not a problem faced by Bangladesh only. It is a problem faced by the UK. It is a problem faced by all over the world, including our neighboring countries and other competitive countries in the region, such as Singapore and Hong Kong. So this problem has always been there. And we can learn from various very strong judicial systems that reforming the civil procedures or their justice delivery system itself has not actually helped. That is why in the last 2 decades, globally, we have gone on to embrace alternative dispute resolution as a means to ensure that access. Because if you can avoid to the court, going to the court altogether, as basically Gauri Gokhale of Nishit Desai Associates have mentioned, that if we can kind of reduce the number of dispute, then we can actually start trying to offer those who need that access to justice to provide them with effective delivery of the justice delivery system. In other words, I would like to re-emphasize on the fact, which Gauri has already made, that is, it is not only arbitration that is a dispute resolution mechanism. We should start training, capacity building, and awareness campaigns for mediation as well, where the parties will not, the first thing they will not do is file a suit or even send an arbitration notice. They will start by actually trying to mediate amongst themselves. And sometimes these bilateral negotiations will not work, because both the parties will kind of say what is best for their own cause. So they will actually need a professional trained mediator to kind of understand what are the differences between the parties and what are the things that are common between the parties, which can then be used to kind of mediate their differences and resolve the dispute. So I think that mediation can be a good starting point. And that brings me to the fact that mediation may not always be successful. And it's very, I would personally say it's very sad that Bangladesh is yet to be a signatory to the Singapore Convention on Mediation, whereas many important jurisdictions of the world have actually gone on to subscribe to the Mediation Convention of Singapore, including India. So gradually we should also consider, and our stakeholders and participants who are here today should also try to do their part in kind of encouraging that as an alternative to traditional dispute resolution mechanisms. As I've said, mediation can fail, and then we can always go for arbitration as a second option. And this option collectively are called MIDARB, where a party starts by mediation. If they fail, they go on to the arbitration as a dispute resolution process. So once we go into the MIDARB, basically the arbitration will then be triggered once the mediation process has basically failed. Now, in this case, I would like to share my personal experiences regarding ad hoc arbitration and institutional arbitration. It is a good thing, or a good trend which we're noticing, is that at least in private party contracts, in commercial contracts that are executed inside Bangladesh, as well as cross-border contracts, we are seeing more and more the use of arbitration clauses. However, we see that most, if not all, of those arbitration clauses are actually ad hoc arbitration clause, where parties basically refer that in case of any dispute between the parties, the Arbitration Act 2001 will apply for the dispute resolution. The problem with ad hoc arbitration, as I have experienced personally, appearing as the legal counsel in many arbitrations in Bangladesh, is that the parties face problems from the very appointment of arbitrator. Therefore, the parties, if they fail to, say, appoint the arbitrator in case of sole arbitrator, or if the parties kind of fail to appoint the chairman, they have to then go to the district court for appointment of arbitrators. And the very fact that they have to go to the district court for that itself, in a form, is a litigation. Therefore, one of my senior counsels once mentioned that sometimes ADR in the Bangladesh context is not alternative dispute resolution. Sometimes it is equated as additional dispute resolution. So how can we address this problem where timeline is not certain, procedure is not certain, even the very appointment of arbitrator itself has to go through the court process where the court appoints the arbitrator? The solution to that is institutional arbitration. I understand that Bangladesh International Arbitration Center is one of the first institution that actually has started to work in the capacity building, and it is also the only country's first and only licensed dispute resolution body in Bangladesh. We need to start actually incorporating institutional arbitration clauses in our respective contracts. Unless we do that, we will still keep on going to and back and forth with the whole process of the court. And as a means of interim relief, will be dependent heavily on the court system. The other important aspect which I would like to mention is the fact that in many of the government contracts, we have not seen arbitration clauses there. So these public sector contracts should also include arbitration clause. And of the arbitration clauses that are currently being used are mostly arbitration under the Arbitration Act 2001. So institutional arbitration should also be incorporated. And very importantly, the very fact that arbitration is basically the party's choice. But sometimes we can kind of, I wouldn't use the word force, but we could kind of really require the parties to go for arbitration if we can introduce statutory arbitration, mandatory statutory arbitration in some of the area of laws. For example, the real estate law of Bangladesh already now requires the parties to kind of mediate, and then there are arbitration procedures involved. And I'm also aware that some of the energy disputes also require arbitration by the Bangladesh Energy, BERC, Bangladesh Energy Regulatory Commission. Similarly, we can apply such similar statutory arbitration requirements in many other cases, including family disputes, including disputes in the commercial context, where the parties should try to mediate and then try to arbitrate, as opposed to having directly access to the court system. One can say that that could then mean that parties are not being given access to the court system, or in other words, parties are being rejected the access of court system. But I would like to say that in those cases, the parties are actually being given access to justice because they are resolving a dispute, not only within a shorter span of time, but sometimes also in a less expensive manner. Because if you accumulate the legal cost for 40 years of litigation, it is always, or in most cases, higher than the 6 months of arbitration. So with these aspects, I would like to emphasize today by saying that all the stakeholders should now work together in Bangladesh to introduce mediation, arbitration, and meet-up clauses. And wherever arbitration clause is currently being used, we should start going for institutional arbitration. Because if we now look in developed countries such as Singapore, you will often see that there is ICC arbitration clause, there is Singapore International Arbitration Center, SIAC's arbitration clause. So they have moved past the ad hoc arbitration. Bangladesh should be doing the same as well. And as Mr. June has very rightly emphasized on the fact that in order to give comfort to the foreign investors who want to invest in Bangladesh, this is very, very much important. Because unless the foreign investors feel the comfort that if I have, whenever I'm executing a contract with the government or with private parties, if I'm aggrieved by a decision, I should have a legal recourse. And that legal recourse should not be years after years of litigation. So Bangladesh, especially the present budget and the past year's budget during the COVID-19 pandemic, is heavily reliant on attracting foreign direct investments. Foreign direct investment attraction is now a top priority of the government, as I understand it. And in order to do that, we must make sure that access to justice is granted. And since it cannot be granted overnight by a reform in the litigation system, ADR is the right way to go about it. And as Jenefa Jabbar has already mentioned, and I'm glad to have her here today as well, as coming from Bangladesh's largest NGO and also one of the world's largest not-for-profit organization, BRAC. They have taken this to the root level. So whenever we are talking about ADR, we should not talk about multi-million-dollar disputes only. We should not talk about the disputes that attract a lot of stake and money involved. We should take that at the root level as well, so that the smallest of the disputes and the most minute of the disputes can also be resolved in a speedy manner. Because for that person who's having a small dispute, for a person who's maybe having a dispute of 20,000 taka, that 20,000 taka may be a big deal for that person. So in order to uphold the very spirit of SDG 16, and in order to uphold the very spirit of the very preamble of the Constitution of Bangladesh, we should make sure that this access is reached by ADR at all levels, starting from the very grassroots level to the level of the state, where, as Gauri has importantly mentioned, is that for regulatory matters, that dispute resolution can also be availed. So with that expectation and with that hope, I conclude my statement, and I'm open to any further questions if required.
Thank you, Mr. Khan, for your prudent deliberation. Actually, developed countries are gradually moving away from traditional litigation due to the costs, delay, and complexities involved, as you have rightly mentioned. And arbitration and mediation must be embraced by Bangladesh to compete in the race of development, as you have said. Thank you so much. We have come to the close of this discussion. Now we have a small question and answer session, before which I would like to sum up what we have learned today from the valuable discussions by the learned panelists from Bangladesh and India. We have learned that effective and executable justice is hard to derive. Justice is derived for cost and delay. ADR can play a key role in achieving SDG 16 by creating new pathway for access to justice in a less time-consuming manner. We've heard that more awareness building among citizens and streamlining the government instruments for arbitration may well advance progress on SDG 16. Good governance is important for ensuring access to justice to attract foreign investors. Strong ADR infrastructure will give comfort to investors worldwide and create a business-friendly environment so that foreign investors feel confident about entering the Bangladesh market. We have also learned that resolving issues came up from marginalized and vulnerable conditions by ADR, which were resolved by ADR by the forum in BRAC, which we appreciate. We have also learned that India is well promoting ADR as part of its drive to secure rule of law at the national and international levels and ensure equal access to justice. We are also privileged to be apprised of some of the progress India has made in strengthening its arbitration institutions. Thus, this forum has suggested Bangladesh's signing of the Singapore Convention on Mediation. We're working on that. A few months back, we had a webinar like this, where we discussed and emphasized the need of Bangladesh signing the Singapore Convention. We urge upon the government to look into the matter, and we hope that we'll work more on this. Now the floor is open for questions and answers. You can ask the panelists questions or ask me to answer. Before that, I have some few questions in the chat box already. If you allow me, I can address some of those. One question was whether BIAC can intervene in family disputes, dowry, maintenance claims, guardianship, etc. BIAC is mandated to deal with commercial disputes only. For the family disputes, there is law and courts in district levels. Next question was by Mr. Suhan Khan himself to me. How can ADR be not only encouraged, but to some extent made mandatory so that people actually avail ADR to resolve disputes? We are arguing for mandatory provisions of ADR. We have referred it to the government, and the government has ensured, and the Honorable Law Minister has said time and again that the government is considering actively whether mandatory ADR provision can be inserted in all government contracts. We are also working on the proposed Arbitration Amendment Act, where we have suggested some provisions to update and make the age-old Arbitration Act user-friendly under the behest of the Law Commission Bangladesh. Then there is a question why BIAC is not going to the Supreme Court bar and the district bars. 80 to 85% bars don't know there is an organization called BIAC. Actually, in these digital days, many people come to know about our activities, even if we fail to reach from door to door. We have already worked on this liaise. We are doing contact programs. We had sessions with the Secretary, Bangladesh Bar Council. We had sessions with eminent lawyers on different aspects of ADR. We have plans to go to the Supreme Court Bar Association and down to the district levels. Basically, we're a small research and training institution. We handle with commercial disputes arising out of big deals, especially between the parties like financial institutions and parties taking loan from them. Yet, we appreciate the question. We'll try to extend our outreach to district levels so that people are aware of our activities and mandate. Ms. Shirin Sheikh Mahbubur has asked for the presentation submitted by the speakers. We'll share those from Suhan Khan and Dr. Mahfuzul Haque later on. There is another question that the Kathmandu School of Law told the questioner that court system should be used as ADR, and the ADR process should be the first in any civil disputes. Look, in the United Kingdom, 100% of commercial disputes are mandated to be settled outside courts. If they fail, then only they are entitled to go to the courts. In our country, it is very difficult to stop somebody in the absence of specific law to go straight to the court. We're working on that. We hope if the government comes forward, there will be specific regulations so that commercial disputes at first instance are resolved outside the court. And is there any question from the audience to any of these speakers?
I have a question.
Yes.
I have a question.
Yes.
Please.
This time the budget for the proposed budget 2021-22 stipulates that the ADR for the tax-related ADR for tax-related issues is being extended from 2 months to 3 months. Now, are there any changes proposed for the ADR period for the utterly Adalat cases?
So far, we know there is nothing new in the budget speech or the finance bill placed in the parliament. Let us see and wait up to 30th June when it is passed and turns into an act with the assent of the president. Let us see if there is anything new.
Okay.
And I would just like to add to Shirinapa's question here. That is regarding the Orthoin Adalat suit alternative dispute resolution mechanism. There are a lot of discussions going on in the stakeholders, but we do not have any specific amendments that provides for the requirement of mandatory ADR as yet. But that is still being considered by the stakeholders, and we really hope not only the legal counsels, but also the parties and banks and financial institutions involved to have something in the very near future.
Thank you.
So now we can look forward hearing our chairman as the last speaker to close the session. I would now request Chairman of Bangladesh International Arbitration Center, BIAC and the BIAC Board, Mr. Mahbubur Rahman, to make his kind closing remarks. Mr. Rahman is the current and founding chairman of the National Arbitration Center and the BIAC Board, an eminent businessman of the country. He is also the president of International Chamber of Commerce, Bangladesh, ICC-B. He is the only arbitrator in Bangladesh at the China International Economic and Trade Arbitration Commission (CITAP). Mr. Rahman is the chairman and CEO of ETBL Holdings Limited and chairman of the International Publications Limited, publishers of the Daily Financial Express. He hosted several international business and economic events in Dhaka, attended by heads of governments, and led many trade investment delegations to a number of overseas destinations, including leading a few business delegations as entourages of the President and the Prime Minister of Bangladesh. Among the 150 high-impact leaders in business and social enterprise from Africa, Asia, Latin America, and Middle East, Mr. Rahman has been interviewed under the Creating Emerging Market Project CMP at Harvard Business School, HBS, USA in October 2020. I request Sir to take the floor and say a few words.
Thank you very much. It has been a pleasure and privilege for me to join you in this very relevant subject for achieving SDG 16. And more particularly, I would also like to take this opportunity to thank one of our partner organizations, the Accord Chambers, for joining BIAC and for promoting alternative dispute resolution mechanism in Bangladesh, which was not available in institutional form in the country before. As someone I heard, they mentioned about to make it ADR compulsory before proceeding to the court. Could be this is an area which we should try to promote and try to see that in the legal system this is incorporated in the country. Bismillahir Rahmanir Rahim. Assalamu alaikum and a very good afternoon to each one of you. Mr. Mamun Chowdhury, the senior partner of Accord Chambers and Advocate Supreme Court of Bangladesh. Mr. Rumee Ali, the Chief Executive Officer of BIAC. Mr. Akmall Azad, the Director and the Moderator of this session. Respected panelists, discussions, and dear participants. Assalamu alaikum wa rahmatullahi wa barakatuh. I'm very happy to join today's webinar, which has been jointly organized by the BIAC and Accord Chambers, our partner organization and the reputed law firm based in Dhaka. Many parties have turned to us for information and guidance in the face of the COVID-19 outbreak, and we are very conscious that these are challenging times for everyone. Under the awareness program in the wake of the current global crisis and the future new norms for the handling of dispute resolution, we have been holding a series of webinars on a regular basis to reach out to our stakeholders for persistent progress of alternative dispute resolution norms in the country. This is the 14th webinar of its kind that we are holding in order to reach our constituents. I am pleased to hear from experts from home and abroad, representing academicians, business organizations, legal fraternity, government and non-government organizations on the theme of today's webinar, how ADR can achieve SDG 16, peace, justice, and strong institutions. Distinguished participants, BIAC, as the country's first and only registered alternative dispute resolution institution, provides its own rules for institutional arbitration and mediation to resolve commercial disputes. We are recognized by the Permanent Court of Arbitration in The Hague. ADR methods are now accepted world over as a means of resolving commercial disputes out of court. The presence of an institution like BIAC is a vital necessity to promote local businesses as well as invite more foreign direct investment. While we are graduating to a developing country by the year 2026, it is very important that we invite more and more people to participate in the process of our development initiative. As we all know, ADR allows the adversarial parties the opportunity to tell their side of the story and have more control over outcome than normal trials overseen by a judge. Many parties desire the opportunity to speak their peace of mind and tell their side of the story in their own words rather than just through lawyers. The aim of today's webinar, inter alia, was to share experiences and discuss ideas that could potentially reduce justice gaps in Bangladesh and other jurisdictions in the region. As I understood from the deliberations in the last hour or so, panelists endeavored to assess the potential role of the institutional ADR mechanism as alternative or complementary justice paths. We are aware that the Goal 16 of the Sustainable Development Goals of the United Nations pledges to promote the rule of law at the national and international levels and ensure equal access to justice for all. And also to ensure peace, justice, and strong institutions as a target to be achieved nationally and globally as well. Whether any country is providing access to justice is determined through the procedures of reaching the justice mechanism by the common people. In our country, justice seekers tussle with some economic, social, and institutional barriers in accessing formal judicial system. Widening access to justice depends upon extending some facilities to the litigants and empowering them to overcome those barriers. In the present-day context of Bangladesh, we are of the opinion that ADR can help achieve SDG 16 with a view to promoting peace, justice, and strong institutions worldwide, integrating its methods as, for example, arbitration, mediation, negotiation, conciliation, etc., with the existing judicial system. What we have learned from today's valuable deliberations by eminent speakers will lead us to a more pragmatic ADR landscape in the country, where the government will have a vital role to play along with regulatory reforms and guidelines, with a view to establishing peace, justice, and strong institutions for the masses in general and the business community in particular. Our heartfelt thanks to Advocate Mamun Chowdhury, Senior Partner of Accord Chambers, for co-sponsoring this event with BIAC. And I'm thankful to all the panelists who are leaders and experts in their own areas at this webinar, including Mrs. Gauri Gokhale, Partner Nishit Desai Associates, Mumbai, Barrister Suhan Khan, FC, the Fellow of the Year of Arbitration, Advocate Supreme Court of Bangladesh, and Managing Partner Accord Chambers, for their valuable insight and contribution. I also thank BIAC team, including CEO Mr. Rumee Ali and the Director Mr. Akmall Azad, who moderated this webinar, and thank to all the registered participants and viewers of this session. And I also must acknowledge with thanks the what is called in arranging this webinar in a befitting manner, our counsel, Rubaya Karishma, no? Rubaya, is it? Her name is Rubaya, no?
Yes, sir.
Rubaya Karishma, thank you very much for organizing it very well. But I understand the Joint Secretary from the for SDG in the Prime Minister's office could not make it, but we look forward, because this is the responsibility of the Prime Minister's office. The special cell has been created to go ahead with the implementation of several issues in the SDG 2030. And here, their participation is also very important from that point of view. We look forward that they join us in our future initiatives. Thank you very much indeed for all registered participants and viewers of this session. And we look forward to your support on making this BIAC, the institution of alternative dispute resolution, in the days to come. And again, I would like to repeat my suggestion that came, that ADR, before you go to the court or any dispute resolution, better you must go through the ADR process and then go to the court. This will be a very, very important area to be addressed in order to make the alternative dispute resolution a significant progress in the area of dispute resolution. Thank you very, very much indeed.
Thank you, sir,
Thank you, and Khudafiz.
Thank you, sir, for illuminating us. You have rightly said that widening access to justice depends upon extending some facilities to the litigants and empowering them to overcome those barriers. In the present day context of Bangladesh, ADR, as you mentioned, can help achieve SDG 16 with a view to promoting peace, justice, and strong institutions worldwide, integrating its methods with the existing judicial system. Thank you, sir.
Thank you very much indeed. Rubaya?
Yes, sir. Thank you so much. It has been a wonderful session, very informative and very interactive. We've had quite a few questions which were answered during the session. Both BIAC and Accord Chambers have worked a lot towards putting this entire webinar together, and having the panelists with us, it has been a pleasure. And we do look forward to having all of you with us in our next events. Thank you so much for all the registrants and viewers on social media as well as on the Zoom platform. We look forward to having you in our next event. Please join us. And thank you. We would like to end the session today, and we would be signing out now. Thank you.
Thank you, and Khudafiz.
Thank you very much. Assalamu alaikum.
Thank you very much.
Thank you very much. It has been a pleasure indeed. Thank you very much, Jun Bhai, for also participating, and everybody else. Thank you very much, Jenefa, Appa, and the esteemed panelists. Thank you very much.
Thank you all once again.
Thank you.
Allah Hafiz.